Okay, we're back at it. How you doing, class? I know this is a little bizarre, and I'm sure you're going through a lot of this with your other classes as well. I'm not sure exactly how they're doing it. They may be using a lot of different platforms. But I hope in terms of yourself and your family, you guys are staying safe. You are taking the precautions because I think now you realize that some of the evidence has shown that, at least the medical evidence has shown that it affects young people as well as older folks. And I remember I saw that video of people running around on South Beach, just frolicking in the beach and, going back to the hotel room and just having big parties. And now a couple of them have tested positive as well. So just be careful. Just know that just because you're younger, you're not invincible. And don't forget that even though you might be carrying it and have little or no symptoms, you might be taking it home to a parent or a relative who might be a little older, who may not be as strong as you. Okay. So a couple of things. Obviously, a lot has changed, especially with respect to what we're doing. The class schedule is slightly off because we're trying to adjust to this new normal. And what I'm trying to do, I'm hoping to get 2 more quizzes and a final in before the end of the year. I'll also post an opportunity for extra credit for some of you. Although most of you did like so well on that last quiz, I might have to make it a little more difficult because there were a lot of 97, 98, and hundreds. That was the average grade on that exam. I don't know if it's just because you guys are brilliant. That may be possible. Or because you had a lot of time to do it. But either way, you guys absorbed the information, you got it, and I think that's most important. There's one lesson that's coming up, which is how to read a legal opinion. And I haven't sent you the material yet, and I'll send it during the week. But I believe that topic, it's difficult to do that topic by, the way we normally, remotely like this. It's not. This is just not a good way to do that because it requires a lot of interaction in order to make sure that I know that you guys are seeing what I'm trying to point to and have you guys actually respond to it. So I'm going to try that Zoom application next Thursday. I sent you an email on it so that you can look at that email for meeting room. Some of your other classes may be doing Zoom. This is the first time I'm doing it. I'm trying it. I think I'm going to try it out with my kids tomorrow to make sure that I know what I'm doing. But and I've set it for the same time that the class will be meeting normally, which is Thursday at 7 o'clock. So you guys have cut out that period of time anyway. So all of you should be available. Okay. So what I want to go over here, this is going to be reasonably short, this class. This class is preceding the topic on wills, which will be the next topic. I'll do a video for that. I have sent you the PowerPoint videos on that. Actually, I sent you the PowerPoint, not just the PDFs. I actually sent you the PowerPoint, so you can look at that. If you're looking at it through a Mac, I have to say that the fonts on it are a little different. It was done on a Windows. When you convert it to a Mac, it gets a little the fonts is sometimes smaller, but the information is there. But so just be careful in terms of how you're looking at it. But I'm going to go over with you anyway. Okay. So this is this is called primary and secondary law, and this is the topic for today. So you will recall that a statute, a law, okay, is a formal written enactment of a legislative authority. And remember, I told you that the legislative authorities here in New York are 2. You have your legislature, the state legislature, which is made up of the Senate and the Assembly, and they're situated up in Albany. They're the ones who make the law for the entire state. The other groups of legislators that you have are the city council here. They're the ones who make up the laws for New York City. All right. So we're dealing with the law that applies across the state. And obviously there's laws that apply across the country, and that's made up by Congress. So that you understand. So recall that a statute is a formal written enactment of a legislative body authority. It distinguishes law made by legislative bodies from the judicial decisions of the common law. So a statute is the law, okay? On the other hand, okay, judicial decisions of the common law are what we said before. They are essentially interpretations, judicial interpretations of the actual law that is written. Remember, I told you that when the legislature writes a law, they're not making a law that is designed to be relevant or apply to every single circumstance. And if a circumstance that was not anticipated ends up in a court of law, a court will interpret the law to see if it fits. And that interpretation is how the law starts to change, and starts to get a little flexible under the concept of what we call common law. Okay. Statutes. And when I say statutes, again, I'm talking about the actual law, not the interpreted law, the law. Statutes are sometimes referred to as legislation written by the legislature, okay, or what law students like to call it, black letter law. Black letter law is the cold law without interpretation. As a source of law, okay, statutes are considered primary law. So when you're looking at the law that the legislature makes, what they write, not the one that's interpreted, the law that is written by the legislature is considered to be primary law. All right. Primary law refers to the categories of legal texts, which are made up of statutes, codes. Codes are, in some legislative books, there are codes that relate to certain behavior and activities, cases, regulations, and treaties created by legislative bodies. The courts and agencies that, taken together, are the legal authority that constitute the law. So when you're looking at the law itself, as we're looking at primary law, okay, not the interpretation, but primary law can be found in several different situations. It can be found in statutes, codes, cases, regulations, or treaties, okay, that's created by legislative bodies, the courts. So when the court interprets a law, okay, that's already in existence, that interpretation also becomes law. Not the explanation of it, but the interpretation, okay? I think when I originally told you, the example I think I gave you guys a while ago was that burglary, the burglary statutes, when they originally were written by the legislators, defined burglary as the unlawful entry into the home of another at night without permission or authority with the intent to commit a crime therein. Okay. And I told you that later on, after that law was being applied to certain burglars, the defense by the attorneys to those people charged with burglary was that burglary was not committed, in that particular case, at night. It was committed during the day. So that being the case, they could not be guilty of the crime of burglary the way it was written. So the courts interpreted the legislature and they looked at what's called the legislative intent. In other words, what did the legislature intend to do when they wrote this law? Okay. Well, they intended to charge people with burglary who unlawfully entered people's homes without permission or authority and had the intent to commit a crime therein. The legislature did not, well, at that point, they had, I guess because there were a lot of nighttime burglaries, it's generally when it happened, they did not presume that it could not happen during the day. That would be absurd. So the court that a case like that would be before, looks at what's called the legislative intent. And that's the writing. And a lot of times when laws are written, the legislature writes down why they wrote this law. They give an explanation of it, okay? And if the court looks at the legislative intent, they're looking to see, well, what did this law intend to do? All right? And as I said, it intended to deal with people who entered people's homes unlawfully. And the court, at some point, had said they make no distinction that it happened during the day or at night. And that is not going to prevent a person, who committed a burglary from being charged with it just because he happened to do it during the daytime. So That new law was being created, has been now being created by that case, which says a burglary a person can be convicted or charged with burglary, even if they do it during the day. That law, that interpreted law, becomes primary law. That is a primary law, okay? Not the explanation, but it also becomes primary law. Now, secondary law, right, refers to the material that purports to explain the meaning or applicability of the actual verbatim texts of constitutions, statutes, case law, administrative regulations, executive orders, treaties, or similar primary authority sources. In other words, simply put, secondary law is designed to explain to you what the primary law means. Again, primary law is the code law. Secondary law is the explanation of where it came from, how it came about, what does it mean, how is it interpreted. Okay, some people suggest actually that before looking at primary law, maybe you should look at secondary law because it will help you understand what the law actually means before you actually look at just the cold wording of the law. Just wanted to get up on the screen this document that I sent to you guys. You guys have a copy of it. So you could just pull it out and let's just go over it a bit. So this is sort of an explanation of what I just said a little while ago, but it's got some actual, pieces of evidence to support it. All right, primary authority. This is just simply from Wikipedia, okay? Primary authority is a document that establishes a law on a particular issue, such as a case, decision, or legislative act. The search for applicable primary authority is an important part of the process of legal research. So the search for any type of law is part of what you're going to do when you're doing a lot of your legal research. In the United States, these are examples of primary authority, i.e. the law, okay, include the actual, when it says verbatim, the actual texts of the following. The Constitution. The Constitution itself is a straightforward legal document, okay? However, it has been interpreted 100 different ways, okay? So the law, though, the constitutional law, is what was written in the actual original Constitution. That is the primary law, okay? The interpretations from it, okay, are the explanations of how that primary law has been changed. So you have the Constitution, you have statutes that are written by legislative authorities. You have court opinions. Okay, court opinions are the interpretations of the actual law, legislative laws that are written by statutes. So again, what I just gave you with the example with the burglary, when that court, in their opinion, wrote that burglary applies now to people who go into people's homes at night, that now becomes primary law, a primary authority, okay? The explanation of how the court got to that, okay, is secondary authority, right? That's an explanation of how it is that primary law came about and how you should use it, right? So more primary law authority, the rules of court proceedings. Those are law. The rules of evidence, not a discussion on the rules of evidence, the actual rules of evidence. Rules governing the conduct of lawyers, administrative regulations, executive orders, treaties and certain other international law materials, municipal charters and ordinances, okay? To be considered primary authority, a document does not have to be physically printed or published by a government entity as long as the document purports to be, and actually is, a verbatim reprint of a statute, regulation, court opinion, etc. Okay? So, all right, the term primary authority is used to distinguish primary authority materials from texts considered to be secondary authorities. Now, this is where it gets a little interesting. Secondary authority, that's where you go to learn and understand what this law really means. Secondary authority is an authority purporting to explain the meaning or applicability of the actual verbatim text of primary authorities. Some secondary authority materials are written and published by governments to explain the law in simple, non-technical terms, while other secondary authority materials are written and published by private companies, nonprofit organizations, or other groups or individuals. And some examples of that are the following. Law review articles, right? Comments and notes written by law professors, practicing lawyers, or law students. Law review articles are written, and we're going to go over that in a minute. Law review articles are written by students and professors in St. John's University right here. It's actually one of the best law review articles in the country, right? And these are articles that are written about new legal statutes and legislative enactments that have come out. And these articles go into how and why these legal texts, these new laws have come about, how they can be used and incorporated into our present day system. Legal textbooks such as legal treaties and hornbooks. Legal digests such as West American Digest systems. Those were at the time when we actually had encyclopedias. You guys would know about that. That's what these were. Annotations published by statute, books, or other materials. Legal encyclopedia such as Corpus Juris Secundum or the AMJUR, American Jurisprudence. Legal dictionaries. Your legal dictionary is a secondary law, secondary authority. It is not the law. When you read it, there's nothing in it about the law. When you're looking at words, it's giving you the definition of words and where they came from and anything more that's connected to it. Restatements of the law, legal briefs and memoranda, tax forms and instructions. Government publications such as summarizing the law, explaining government publications, explaining or summarizing the laws. You've just been in a situation, if we just explain what's going on right now. This COVID virus has come out and it's affected everyone. So nobody's working, people aren't getting money, and a lot of people who have those jobs that don't pay them unless they go there are really getting strapped. The government, in an effort not to shut the system down and to ensure that the economy keeps going, has decided to infuse the economy with money by giving money to people, giving money to hotels because no one's going to hotels anymore. Banks, I'm not sure why they're giving it to the banks, but hotels. Airline industry, the cruise ship industry, you could see everyone that's been negatively affected by that. The small business person. Okay. How did that all come about? That all came about because Congress, the House and the Senate got together in their respective parties and came up with a law that XYZ has to be done in order to help the people at large. Okay. The two houses got together, they voted on it, and it got passed. Then it goes to the president to sign. Only when the president signs it does it go into law. It becomes law. Now, what you'll find is that there's several articles and magazines out and writings out now that explain to you what this stimulus means. Okay, it explains it. Because the stimulus doesn't explain itself. It's not really that clear. The stimulus just says X to the X money to this. It doesn't say, may not say why, okay? The writings that are coming out about it, some of which are government publications explaining or summarizing the law, okay? Actually explain why we're giving the hotel industry, $8 billion, why we're giving, we're telling students they can take off until September on paying back their student loans. Why are we doing all these things? That explanation, wherever it's written, is a secondary authority because it is explaining what the law is, the primary law being the $2 trillion stimulus package. That's the law. Everything that is written about it, explaining to help you understand whether or not it applies to you. Does it apply to your mother, your father? Which kid can get it? Those are all secondary authorities. That's the easiest way to explain this thing to you, okay? Course materials from continuing legal education seminars, debates in legislatures, including the commentaries published by the Congressional Record, and other similar materials, okay? So now I want you to just go to the other page that you have. Let's see if we could open this up and put it in the middle of the screen. Ooh, too big. Okay, what you're looking at here is actually a law. This is a law. It's L 2000C1 legislation. Okay, subdivision 2, all right, L 2000 C1 section 11, okay, rewrote subdivision 2, which had red. Okay, this is actually a rewriting of a particular law, but I don't want to get too deep into that. Let me explain to you what this one is. I'm going to read it to you. Every witness more than 12 years old. Okay, first of all, what does this have to deal with? This law had to deal with a child witness who's testifying in a case, generally in a criminal case. It happens in civil, but a lot of times in a criminal case. So in a criminal case, you might have a child that maybe the child was sexually abused, or maybe the child saw something happen at their home, a crime occur. And so the question is, that child is a witness, yes, but can that child testify? Is that child old enough to testify? And does that child understand the meaning of taking an oath? Take an oath, you have to swear to tell the truth, and not lie. Does the child understand that? So this law goes directly to that. Now, this is the law. Okay. Every witness more than 12 years old may testify only under oath unless the court is satisfied that such witness cannot, as a result of mental disease or defect, understand the nature of an oath. So again, every witness that's more than 12 years old, that's over 12 years old, okay, may testify under oath, okay, unless the court is satisfied that such witness cannot, as a result of mental disease or defect, understand the meaning or nature of an oath. Okay, so that means if the child seems fine and the child is over 12, if the defense attorney said, Judge, I object to that child being a witness. That child is over 12 years old. They're 13 years old, and I don't believe that they would understand the nature, and integrity of taking an oath. All right. The judge would simply refer to this legislation. No, counsel. The law is that if this child is over 12 years old, as long as this child does not suffer from a mental disease or defect, okay, that prevents them from understanding the taking of an oath, all right, they can testify. Now, and the court may inquire, because of that child, whether or not they do understand, if there was a reason to even go into that. But there's a presumption that if you're over 12, you're just like anybody else. Okay. What about if you're younger? A child less than 12 years old, okay, may not testify under oath unless the court is satisfied that he understands the nature of an oath. Okay, so what does that mean? So if you're older than 12, that's enough. If you're older than 12, you might as well be 50, because it's presumed that by the time you're 12 years old, you understand the nature of telling the truth versus a lie. Okay. If you're under 12, okay, all right, that presumption doesn't go with you. Okay. It's not automatically presumed that you know. So it says it right off the bat, a child less than 12 years old may not testify under oath unless, okay. So that tells you the court has to do something. The court has to be satisfied that he or she understands the nature of an oath. Okay. So what happens? The court is going to undergo, for the child at less than 12, is actually going to proactively speak to the child, sit them down, and ask them the regular questions. Do you know where you are? Courtroom. Who am I? I'm the judge, and what am I supposed to be doing? And when people take an oath, what does that mean? Do you understand the meaning between telling a lie or telling the truth? Yes, I do. Tell me what it means. Well, they'll say whatever they say. And eventually the court may make the determination that even though this child is 8 years old, i.e. under 12, okay, that they do understand the nature of an oath, and they can take the stand and they can testify about whatever they saw or heard that's relevant to this case. If they're over 12, they can just do it and take the stand unless someone says or proves that they have a mental disease or defect or somehow they don't understand it. All right. So that is the cold-faced law. Now, the first thing we come across is the following. says practice commentaries, okay? A commentary, and that word is comment. This individual, Peter Pricer, is commenting on this law, okay? And what does he say about it? Subdivision 1 sets forth the modern, well-established general presumption of competence for all witnesses, okay? The opposing party has the burden of proving incompetence. More importantly here. As a basic proposition, the law requires that every witness testifying under oath testifies under oath. The object of this requirement is to foster truthful evidence by alerting the witness to the moral duty to testify truthfully and by deterring false testimony. All right? Okay. There is, however, an exception to the basic requirement applicable where a witness cannot understand the meaning of an oath due to the lack of maturity or to mental disease or disorder. All right. Let me go further. Accordingly, such persons are permitted to give testimony required under another statute for different reasons, rejecting the argument that this is the same as the insufficiency of corroboration. Okay, so he is talking about it. He's talking very complicated about it. Okay, but he is giving you what he believes is his opinion on this particular law, and what happens here is that you're going to get cross references to his article and to that law that was written. So look at all the cross references that you have. These are all secondary authority. That's the law. That's the law. Everything else that you see below you, starting here, that's all secondary authority. Look at the cross references. First, what does it say? People versus Henrik, People versus Vasquez. Why are these two cases here? These two cases are here because in these two cases, they discuss the concept of a child testifying under oath, either above 12 or not 12. Okay? Corroboration. Corroboration deals with, exactly that same process. Whether or not evidence can be corroborated, but can it be corroborated by a child? Child protective proceedings, closed circuit television for certain child witnesses. Certain children cannot testify in open court. They might be, it might turn out that they are competent to testify because they understand the meaning of an oath and can tell the truth, and they understand what's bad about telling a lie, but they're too scared to testify in an big open courtroom. This, for example, closed circuit television for certain child witnesses. So the court may set up a situation where the child is in a small room just by himself or with his parents, okay? And the child can hear exactly what's being asked of him or her, and they answer the questions. So the jury gets the benefit of their answers, and the child is not so scared that they will not testify. But my point is that all of these things here, criminal facilitation, criminal possession of stolen property, perjury and related offenses, okay, mental disease and defect, all right, all of these things relate to child witnesses. All are secondary authority, general rule of witness competency, okay? All of these things relate to child witnesses. There's more. In every one of these cases, in every one of these issues, theft as an accomplice of one charged with receiving stolen property or vice versa, within corroboration. Within this writing, this article, was an issue that dealt with what we're talking about, okay? Prosecuting attorney as a witness in a criminal case, entrapment defense in a sex offense prosecution, okay? Competency to stand trial in a criminal defendant diagnosed as mentally retarded. All of them relate to this topic in one way or the other. All of these, American Digest Systems, criminal law, this is a book, section 562. Look under witnesses from 40 to 41 and page 45, subsection 2, relates to witnesses, child witnesses. Encyclopedias, which are now digitized, which don't exist anymore. Well, they're probably still there, but I'm sure nobody opens them anymore. All of these things relate to child witnesses. Look, listen to this. Texts and treaties. These are actual lengthy treatises, meaning writings that relate to this topic, okay? And AmJur, American Jurisprudence, all of these are all secondary authority items. So all of these things you can go to, and within it, it deals with the one topic that we were originally talking about, which has to do with simply a child witness testifying. And it goes on and on. This simple section, and just the same thing, I gave you that statute, burglary, the simple law, the unlawful entry to the home of another with the intent to commit a crime therein. There are hundreds of commentaries and articles and cases that relate to burglary, okay? And all of those things are secondary authorities that help you understand the simple law that I just gave you of burglary. And that is what is most important about this whole situation. So that is simply primary versus secondary law. You should know it when you see it. Again, when you see just a cold law, just a straight law, okay, with no explanation, that is the law. That is a primary authority, okay? Anything else that you see that helps you explain that, helps you to understand it, is considered a secondary authority. As you as a lawyer, as a paralegal, or in a law firm assisting a lawyer, you will spend most of your time on secondary authority because you'll know what the law is, and you have to try to understand it and try to find another way around it in order to help your client or help the attorney that you're working with or working for to find other options that you may have. Okay, that's those topics. Thank you.